Good afternoon, and thank you, Mayor, and she does a great job. So Southfield's not on our radar. They're healthy and fine, and
I thank
under
you for
your
that.
great leadership, we don't have a headache with Southfield. I want to start with maybe a little story or an example. In the city of Taylor, you had a lifelong resident who was a retired police officer become the mayor. And he realized that you had police retiring after 20 years with pensions over $100,000 a year. It was an unsustainable model that they had in Taylor. So he set off to collectively bargain changes to the agreements that they had reached with police and fire. And in the next election cycle, the police and fire aggressively got behind his opponent, and he was defeated, and it stopped all the reform measures for that city. And these unsustainable wages and benefits that are provided to public employees are unsustainable for many communities, not all. But for those that it's unsustainable, we get a city in a condition of being unsustainable and facing insolvency. For the most part, if you look at any local government unit, whether it be a city or a school district, 75% of their expenses are wages and benefits. So if you have a community that's running deficits or approaching insolvency, and you can't touch 75% of your expenses, it's very difficult to solve the problem. As we went through the review for Detroit, you've probably heard that there's 48 different collectively bargained agreements in the city. That includes the law department. The lawyers that now issued this opinion that said the agreement is not valid, the consent agreement is not valid, was issued by unionized lawyers. There's other agreements between the city and the state that are necessary for the city to access the public markets, to borrow monies, to have the state police process the 10,000 rape kits that were left unattended by the Detroit Police Department. So it's not just the consent agreement that's now held in jeopardy, it's also very important agreements to the city. In these agreements that we have, 48 different agreements with the city of Detroit, there's provision in there that says you can't privatize anything if there's one lost job or any lost overtime. So if you look at what we discovered during the review, the City of Detroit Police Department, it takes 85 full-time employees just to process the payroll. That could be done with ADP or paychecks, but you can't do it because in the collectively bargained agreements it prohibits that. And we have a city, obviously hemorrhaging dollars, that can't reform itself because of 48 different collectively bargained agreements. And the argument that this is anti-democratic, I would disagree. In fact, the version of the predecessor to PA8 was called Public Act 72. It was passed in 1988 with a Democratic legislature and a Democratic governor. And in there was a provision that said that if a city faces insolvency, that the governor can allow them to proceed into Chapter 9. Chapter 9 is a bankruptcy provision for municipalities. A federal judge has more power than an emergency manager and is a lifetime appointee and never sets foot in the community, most likely. There will be no accountability to a federal judge from the community in terms of what direction a city should go to, but that federal judge can undo pensions, can undo health care, can undo collectively bargained agreements. So I would argue that the vote for PA 72 was just as anti-democratic as a vote for Public Act 4. There's some allegations that Public Act 4 is not constitutional, and I would argue that it is. In the Constitution, I acknowledge that there's a provision that says you can't undermine contracts, that the government can't interfere with a contract that's negotiated between two parties. However, there's another provision in the Constitution that says we at state government have a responsibility to provide for the public health, safety, and welfare of the residents. Those are competing provisions. And when you get to a condition like we do with some of our cities that are insolvent and running massive deficits and can't deal with 75% of their budget, the ability to provide for the public health, safety, and welfare of the residents is of great concern, and you'll have two competing priorities of the Constitution. And what the courts have ruled in the past is in that environment that the obligation for public health, safety, and welfare would take precedent over the provision to maintain the integrity of contracts. And if you look at the language of PA4, it basically says it has to be a temporary modification. It doesn't say this is a permanent, we're blowing up the contract. And I will just close by saying some of the points that the mayor raised, I acknowledge. And in our contracts with our emergency managers under our tenure, have said you have to meet with the mayor, you have to meet with the council, you have to be available to the public and to the media so people understand what you're doing. So we're trying to make it a newer, softer side of PA4 through the contracts we have with the managers, because we understand that there's some controversy with this.
Okay. Well, I just want to double check before we get, yeah, okay.